first one, and then we're going to meet up on the third floor rotunda have a coffee break with council, and then we'll come back and do the following three cases. The first case this morning is State of Florida Department of Economic Opportunity versus Consumer Rights, LLC. Mr. Nordby.
Thank you, Chief Judge Roberts, and may it please the court. I'm Daniel Nordby from Schutz & Bowen on behalf of the Department of Economic Opportunity. I'd like to reserve 5 minutes for rebuttal. This is an appeal of an order awarding over $150,000 in attorney's fees and costs in a public records case. The parties' briefs raised a variety.
I believe the trial judge said that was entirely or largely the department's fault.
The trial judge did make some findings to that effect, Judge Benton.
So that's kind of a fact, isn't it? The number of hours that was awarded and the amount per hour, we're kind of bound by that, don't you think?
Judge, I agree that you're bound as to the factual findings, but with the court's indulgence, I plan to focus my time this morning on the principal legal issue that we believe compels reversal here, which is the plaintiff's failure to comply with Section 284.30. If the court has questions as to specific arguments on the time entries and rates, I'd be glad to address those. Otherwise, we'd rely on our briefs as to those arguments. Okay. As to the principal issue, Section 284.30 explicitly requires a party to a suit in any court to be entitled to have his or her attorney's fees paid by the state or its agencies to serve a copy of the pleading claiming fees on the Department of Financial Services. The trial court found that DFS had not been served here, but then with no textual basis or analysis concluded that the plain language of the statute, quote, does not apply to litigation under Chapter 119. And that's in the record at page...
The only authority was the prior decision of another circuit judge.
That's correct, Judge Benton. There was a prior decision from Judge Carroll in the Second Circuit, which was, we submit, contrary to the longstanding and consistent precedent of the District Courts of Appeal stretching back more than 25 years.
But there's no decision that definitively addresses this issue, correct?
I disagree, Judge Roberts, respectfully. There are several decisions addressing the applicability of Section 284.30, and they have consistently described it as a condition precedent to the recovery of attorney's fees. We've cited the Heredia case from the 3rd District affirming denial of fees under section for failure to comply with Section 284.30, the Cortez decision from this court, the Goodman decision from the 4th District Court of Appeal. All of these courts, that every court that has addressed this issue.
Or no, the statute itself doesn't really say that, right?
Correct, Judge Benton. The statute requires service of the pleading on the Department of Financial Services, but the District Courts of Appeal have consistently said, every District Court of Appeal to address this issue has stated that this is a condition precedent to the recovery of fees and has routinely denied recovery of attorney's fees for a plaintiff's failure to comply with this requirement. The one case in which the court found a waiver was this court's decision in Florida Medical Center, and that was where the agency first raised Section 284.30 in a motion for rehearing after an award of attorney's fees was entered. Other than that one decision, the District Courts of Appeal have consistently applied this statute to deny attorney's fees for a plaintiff's failure to comply with the condition precedent. And the plaintiff in this case, it's undisputed on this record, failed to comply with the condition precedent by serving a copy of its pleading on the Department of Financial Services at the commencement of this action. The trial court's order finding that Section 284.30 doesn't...
You say the case, that the question is decided in the 1st District. Would you say Cortez? What did you say?
Judge, I referred to Health and Rehabilitative Services versus Cortez, the 1st District's decision from 1994, reversing an award of attorney's fees under Section 120.69 for failure to comply with the requirements of Section 284.30. Judge Benton, I believe you were on that panel, and the court said that there was not a waiver in that case because the agency timely raised Section 284.30 in its motion to strike the claim for fees. But that's not the only case from this court addressing this issue. The Hale decision, Hale versus Department of Revenue from 2007, is another decision from this district affirming a denial of attorney's fees for failure to perfect, this is a quote, failure to perfect service on the Department of Insurance with a summons and a copy of the complaint at the commencement of the action pursuant to Section 284.30. And that's at page 520 of the Hale decision. Again, these were fees, in that case, brought under the taxpayer's Bill of Rights, but this is a generally applicable condition precedent that applies to any cause of action against a state agency in which attorney's fees are being sought. So the fact that a district court of appeal has not specifically applied this to Chapter 119 attorney's fees, department submits is not relevant to the analysis because it applies to every type. And public records cases certainly are very important, but so are Civil Rights Act cases under Section 1983, which was the statute involved in the Heredia case. The Third District Court of Appeal affirmed a denial of attorney's fees in that case. The Environmental Protection Act of 1971 was addressed in the Goodman case. That's an important statute, but the plaintiff's failure to comply with the condition precedent resulted in a denial of attorney's fees in that case. The same result should obtain here under Chapter 119. If the plaintiff had served a copy of its pleading on the Department of Financial Services at the commencement of this case, that issue would not be in play here. Their failure to do so, we argue, is dispositive on the legal merits.
Okay. So you're going to talk about Union County now?
I could talk about Union County, Judge.
You talk about whatever you would like to, Mr. Orby.
I want to talk about whatever you want to talk about, Judge. The Union County case was the second case involving the same plaintiff here, Consumer Rights LLC. This is the third case within the last year where Consumer Rights LLC has been in front of this court.
What was the first case?
The Bradford County case.
Okay.
Consumer Rights LLC versus Bradford County. And each of the cases has reached this court in a slightly different posture. Neither of the two prior decisions involved a claim that the plaintiff had failed to comply with 284.30. It simply wasn't an issue raised by Bradford County or Union County. So as to that aspect of the case, it's in front of you for the first time in this case. Judge Benton mentioned earlier the McGee versus Commission on Human Relations case, which is the prior Second Circuit case addressing this same issue and concluding that 284.30 doesn't apply to public records cases. The department submits that there's not a legal basis to rely on abstract public policy or the importance of the Public Records Act to depart from the plain language of Section 284.30.
They didn't go up in that case.
That's correct, Judge. It's a trial court decision that was not appealed. Judge Hankinson indicated at the September 22nd hearing that he had read the decision and he agreed with it, but it was not subject to any appellate review. And in a different context, in the Levine case that we've cited in our briefs, Levine versus Dade County School Board, the Florida Supreme Court said, in the context of a different notice requirement, that the courts are not authorized to ignore the plain language of the statute based on their views of the wisdom or propriety of the requirement where it's clearly set forth in the statute. We believe that analysis applies equally here. Plain language of Section 284.30 requires service of a pleading claiming attorney's fees on the Department of Financial Services. District courts of appeal have consistently said that that must happen at the commencement of the action. The plaintiff has raised on a...
This is a merely technical argument. You don't deny that the DFS had actual notice virtually from the beginning.
Well, Judge Benton, the department certainly notified DFS of the lawsuit at its commencement. Like all agencies, the Department of Economic Opportunity has its own separate statutory duty to notify DFS of any known or potential claim. But that's Section 284.385 of the Florida statutes.
So even with actual knowledge, if you don't do this, you're not entitled to a recovery.
That's correct, Judge. The department is required to the Department of Economic Opportunity and all agencies are required to notify DFS of known or potential claims under a separate statutory obligation from the condition precedent here, Section 284.30. If one were to read the department's compliance with its notice requirement to the Department of Financial Services to eliminate this condition precedent in 284.30, then there would essentially be no condition precedent in 284.30. That statute...
But isn't one way to look at the statute is it's giving two requirements, and basically the objective is so DFS knows and can participate, which of course occurred here. Not only did they know, but also there was this coordinated response.
Well, Judge Benton, I think the record certainly reflects that DFS was informed at the commencement of this case that it existed and that other cases like it existed. I think it's less clear how much DFS participated in this case. But I'd submit that that's not a reason to disregard the condition precedent language in 284.30, which is the plaintiff's obligation and which is no more burdensome than service of the complaint on the department itself.
There is no condition precedent language in 284.30.
Correct, Judge Benton. The statute does not specifically say it, but this court's opinions going back to the Florida Medical Center opinion in 1987 have described this as a statutory condition precedent. We don't believe there's any reason to depart from those decisions here. I see I'm into my rebuttal time. Thank you.
Thank you, Mr. Irby.
May it
Mr.
please the
Case.
court.
Yes.
I'm Robert Earl Case Jr. on behalf of Consumer Rights LLC. I want to go to the order where Judge Hankinson rejected their 284.30 argument and point out from the outset that he ruled, and I quote, Section 284.30 Florida statute does not bar plaintiff's claim for attorney's fees under the facts and circumstances of this case. He went further to say that Section 284.30 Florida statutes does not apply to litigation under Chapter 119 of the Florida statutes. And he also had me say that he was specifically not finding a waiver. But he did find that 284.30 did not apply under the facts and circumstances of this case.
But that's a conclusion of law, correct?
It is. It was at an evidentiary hearing, though.
Okay, so our review of that is de novo, correct?
I don't think so, Your Honor. That was a subsequent to the motion for summary judgment. It had been granted. I noticed an evidentiary hearing on whether or not 284.30.
No, but his statement that 284.30 does not apply to Public Record Act cases is a legal conclusion.
Yes, sir.
Which is usually subject to de novo review.
Yes, sir.
Okay, so
Yes, sir.
show me some cases.
You want a case for what exactly?
To support that proposition.
Why do you just read out the requirements
why
right
doesn't-
there in the statute?
Okay. Why it doesn't apply? I support the reasoning in Judge Carroll's opinion that given the nature of the public records law and the almost presumptive access and how quickly they generally occur, that it doesn't apply.
So the argument is the Public Records Act is largely supposed to be self-executing and to allow citizens access to documents without having to resort to litigation. And when litigation is required, it should be quick and expeditious.
I did make that argument in my brief, Your Honor,
Okay.
to justify Judge Carroll's reasoning and go further on that analysis. I also pointed out the Johnson versus Jarvis case that I believe you were on, and that was a simple case where they were arguing that on remand he couldn't get appellate costs under 119.12, the statute that we're here about. And you all ruled in that case that 284.30 did not apply to a claim for costs under 119.12. And I made the argument, and I concede it's a technical argument, but everything we're talking about here is technical, given
Sure.
what we know under the facts of what occurred with regard to 284.30 in this case. The technical argument is that attorney's fees are awarded as a cost under 119.12, which is a little bit unusual. Most fee statutes just award them as attorney's fees. The statute specifically says that it's awarded as a cost. So where the Jarvis decision says that 284 doesn't, 284.3.
Is there any place else in the Florida statutes where attorney's fees are called a cost, where we can look to find a case to see if it applies?
I'm not aware of one, Your Honor. It's, like I said, it's odd. But under the facts of this case, with regard to 284, see, their whole argument about 284.30 is this notion that it's an automatic thing, that it's jurisdictional, and that's not consistent with the case law. The case law says it can be cured. And the fact in this case, it's undisputed, is that I did serve a copy of the pleading upon DFS. I did it 10 months after the lawsuit was filed. I was doing some research, getting ready for another hearing, and I saw this argument made in another case in the circuit court there, and I said, oh my goodness. If this does apply, I need to do it now. So I e-served them on March 21st. Their argument is that it's automatic, that you didn't do it at the beginning of the case, even though they had actual notice. And they were participating in the defense. DFS was even discussing this 284.30 argument with DEO. and sent them a copy of the order that Judge Hankinson ultimately relied upon. So they got everything the statute required. So then when I served, the law says you can cure it's a temporary procedural bar, and you can cure it. So then when I served on March 21st, 2014, what was there left to cure? And as I argued in my brief, the only thing left.
Well, what case do we look to find that?
Temporary procedural bar. I don't have it at my fingertips, Your Honor. I'm sorry. I'm not.
Okay.
He says that Hale and Florida Medical Center established that it is a condition precedent.
I respectfully, I acknowledge those rulings, and I respectfully disagree that it is a condition precedent under the current state of the law. And as I said in my brief, I pointed to the Supreme Court of Florida's subsequent decision in Public Health Trust versus Aconda. That's a 2011 case that's subsequent to those other cases. And what they said, we got some similar statutes that you all have looked to figure out what 284.30 means. 768.28 is what you all have looked to interpret 284.30. And in Aconda, the Supreme Court looked at 768.28(7), which talks about service of process, and said that it's not a condition precedent, primarily because it doesn't say that it's a condition precedent. And if you look to 768.286, which is where y'all originally got the idea that it was a condition precedent under 284.30, look into 768.286. That's where you all look to get that ruling that it was a condition precedent under 284.30 originally. The Supreme Court looked at 768.287 and said, since this legislature clearly knew how to make it a condition precedent, because they did it in 768.286, if they don't, then it's not. And 284.30 does not say that it's a condition precedent. The Supreme Court
Right,
said,
but Aconda was not construing 284.30.
no, sir. It was construing 768.287, paren 7. But
So there's controlling precedent in the first district saying that it is a condition precedent.
yes, sir. And the way I suggest and argue that this reasoning overrules that previous precedent is because when you all established that previous precedent, that it was a condition precedent under 284.30, you all expressly looked in those cases to 768.286. The same place as
opinion Judge Irvin wrote.
I don't recall, Your Honor, I'm sorry. But y'all looked to the same place that the Supreme Court's now looking in the Aconda case. They looked to the same statute. Y'all looked to it. You saw that it didn't say it was a condition precedent, but it didn't bother you. And you said it was a condition precedent under 284.302, even though it didn't say condition precedent. The Supreme Court in Aconda looked at 768.28 and said they knew how to make it a condition precedent. And if they didn't in 768.28 paren 7, then it's not. One other point about Aconda too, they make in a footnote at the very.
So you're saying that one of the premises in one of the cases cited as precedent for the proposition that service is a condition precedent.
Yes, sir.
Has been undermined. But that doesn't mean that the president doesn't stand in control.
I've just argued that it is clearly overruled, disagreed with, whatever you want to call it, by the Florida Supreme Court when they look at that same statute and say if they knew how this legislature knew how to require it as a condition precedent, and they didn't here, so it's not. And that's all I can say about it. I mean, that's exactly what happened, and the opinions are clear. But one other point they make in it, in a footnote, they point out 768.287 requires you to serve process on DFS. The Supreme Court points out, how do you plead that you satisfied that in your complaint when you do it after you file your complaint? They point that out in a footnote. They say clearly it's not a condition precedent because you can't honestly plead that, hey, I've served them until after you filed your complaint. The same thing with 284.30. And by the way, while we're talking about this, if it's not a condition precedent, they have to have it be a condition precedent to win this argument, because if it's not, they weren't allowed to lie in wait and spring this 284.30 argument over a year or so into the litigation. If it's not a condition precedent, they were supposed to plead it as an affirmative defense at the outset of the case in their answer and say, hey, you didn't serve DFS, they don't have notice and an opportunity to participate.
Are you arguing that?
Sir?
Are you arguing waiver by them?
Yes, sir. If it's not a condition precedent, and they didn't put it in there, if you agree with me that it's not a condition precedent, given the Supreme Court's ruling in Aconda, and they didn't raise it in their answer, there's law out there that says that's a waiver.
When did they raise it?
They raised it in response to my motion for attorney's fees that came after motion for summary judgment was granted by Judge Cooper, and that was about a year to 13, 14 months after the lawsuit was filed.
So, 2 to 3 months after you had served.
Yes, sir. I served before the motion for summary judgment was granted. I served before any real order was entered. What would have been different in this case if Lord, I wish I'd gone to the sheriff's office and had them take a copy of this out there. I don't even know what the summons would say, by the way. What does the summons say for a 284.30 service? The lawsuit's not filed against DFS. They're not a party. But anyway, I wish I had done that. What would have been different if I'd had the sheriff's department go out there and serve process on DFS at the beginning of this lawsuit? Nothing. Because
again, the statute doesn't say process. It just says
it doesn't.
Serve.
And I pointed that out in my brief, because 768.28(7) does require process, 284.30 does not. And so I point out that the legislature knew, because I e-served, and I was afraid they were going to say you should have taken a summons out there. But I e-served them in accordance with the rule of judicial administration and rule of civil procedure that we have now in e-service.
Which I think is probably sufficient. How is this case different from Union County?
This case is different from Union County because obviously I disagree with Union County respectfully.
Well, I could disagree with it, but it really doesn't matter.
I understand.
That's
I will point out
this court,
Yes, sir. I will point out that the Bradford case that Judge Benton was on the panel there, it was different procedurally, but it involved the exact same public records request, just sent to a different county. So their argument is that this Union case is some magic bullet that they can raise for the first time on appeal, and we win because Mr. Case and Consumer Rights have some scarlet letter on their head as schemers or whatever, which I reject. Well, I don't think we need to get into that unless you need me to. In the Union case, they raised a defense factually that they thought it was phishing. They thought the request was phishing, so they ignored it. In this case, two different circuit judges, Judge Cooper and Judge Hankinson, have looked at what they did in response to the motion for summary judgment, and both of them found that they didn't say anything about any of the union arguments to justify their delay. They didn't raise anything to justify their delay whatsoever. Two judges have said that, and they've not shown any error with those two decisions. They just come in for the first time on appeal now that Union's here. And I pointed out throughout my brief, they're making arguments for the first time on appeal, trying to shoehorn this case into the Union case.
Well, if there's new case law, generally you can argue that on appeal, even if it didn't exist at the time you had the trial.
Yes, sir, if you raise those arguments below. I looked it up because they made that argument, and I found some cases that say, yes, you can do that if you raise those arguments below. But the Union was based on the facts of the case. Union says we're going to defer to the trial judge, and he can find these facts, and that can be a legal justification. I'm saying defer to the trial judge here too, because they had the opportunity to raise any defense they want to justify their delay, and they didn't do anything. All they raised was this standing argument. Now they did raise.
So they didn't raise the argument at all that this was, kind of a business model thing, sending sending emails to random state employees as a trap for the unwary. They didn't mention that before Judge Hankinson?
Well, it wasn't random. I testified in my deposition to the purposes I had for picking these employees. I didn't pick them randomly. I did a little research on them and wanted to know what they did and what they made for $75,000 or whatever. I'll tell you where they raised it. They raised it at the fee hearing for the very first time, saying I should get 0 attorney's fees because this is all one big scam. That was the first time they raised it. And on that point, legally speaking, Hankinson took all that in and considered it and gave it whatever weight he thought. And you all respectfully should defer to his decision on that. That was the first time they raised it. They didn't raise it like it was raised in Union. In Union, they came in and said, look, we ignored this because we thought it was phishing.
They never argued below that the delay was justified.
Never. They thought they did. They made a motion for reconsideration after the summary judgment, but if you read the motion for reconsideration, they clearly don't understand how a motion for summary judgment worked. Because I went through all the evidence I had, summary judgment evidence that their delay was unjustified. They presented nothing. And they actually, if you look through the transcripts of the hearing, they actually concede that it was just a mistake, somebody dropped the ball, and it was untimely.
But you're saying they did argue it in the motion for rehearing of summary judgment?
They argued that they should get an evidentiary hearing, but they never said anything in, and I pointed this out, they never said anything in their motion for reconsideration of the summary judgment as to what they would argue, what their argument was. And they never said anything about it. They just said, you can't do this, Judge Cooper. You messed up. We need to have an evidentiary hearing. And I pointed out, you know, you got to contest a motion for summary judgment once the initial burdens are met by the movement, and they were. I see I'm out of time. Thank you very much.
Thank you, Mr. Case. Go ahead, Mr. Orban.
Thank you, Judge. Just briefly on a few issues. Judge Hankinson did conclude that the requests here were a trap for the unwary. That's at page 1877 of the record. But at least as important as that, the trial court found no waiver of Section 284.30 by the Department of Economic Opportunity here. That's both in the order from the September 22nd hearing at page 1244 of the record and the transcript of that same hearing at pages 1714 and 1715 of the record. The judge said, if I thought that 284.30 applied, I would not find a waiver. This court in the Hale decision that I mentioned earlier said that whether waiver has occurred is a question of fact reviewed for competent substantial evidence, and there's certainly competent substantial evidence in the record here to find no waiver. In the Hale decision itself, in fact, Section 284.30 was first raised 6 years into the litigation after that case had already gone up to this court and backed down on the merits. So raising 284.30 at the time that the department did is certainly not a waiver as found by the trial court and as supported by competent and substantial evidence. I want to address...
Do you agree it's a fair reading of the record that nothing was argued below to justify the delay?
Judge, I'd agree that the principal basis on which the department opposed summary judgment was the standing argument. The question of the factual question of whether Mr. Case was in fact acting on his own behalf or as an agent for Consumer Rights LLC at the time he made the request, and therefore whether he or his partner in the LLC or Consumer Rights is the proper plaintiff here. I certainly agree. That was the principal basis on which the department opposed summary judgment. I wanted to address the Aconda case from the Florida Supreme Court that Mr. Case mentioned. As the court noted here, that did not involve Section 284.30, so the department believes this court would be compelled to follow its prior precedent because it has not been overruled. But even under the facts of that case, I think there are some important ways to distinguish the holding there from the situation under 284.30. One of the key findings that the Supreme Court made in concluding that subsection 7 of 768.28 did not impose a condition precedent was a comparison of paragraph 6b of that same statute. 768.28 6b explicitly states that a notice requirement in that paragraph is a condition precedent, and the court said that it was instructive that one provision of a single statute referred to a notice requirement as a condition precedent, and another did not. So distinguishing those two provisions of the same statute, I think, is important. Here we have more than 2 decades of district court precedent concluding that 284.30 is a condition precedent. Another important fact about the Akanda case is that in that case, the condition precedent would have served as a complete bar to the cause of action for negligence. Here, the department certainly isn't arguing that the condition precedent here under 284.30 would bar an entitlement to inspect or copy records. It's only as to the attorney's fees, which are addressed by 284.30. So I think those are 2 important reasons. Also, the NS decision, NS versus DCF, which was a decision of the 5th District Court of Appeal from 2013, after the Akanda case, continued to refer to 284.30 as a condition precedent, citing Heredia, Hale, Goodman, and the other prior district court cases. So I think those are all very substantial reasons not to apply the reasoning of Akanda to this case. On the service issue,
You're saying NS came after Akanda?
It did. It was a 2013 decision. Akanda was from 2011. On the service issue, briefly, the opposing counsel emailed a copy of the complaint to DFS almost a year after this case began. The cases I've cited earlier and that are cited in our briefs require that condition precedent be satisfied at the commencement of the action. It was emailed here.
So service by email is good enough. There's not an issue there.
The trial court found that service is a term of art, and that it wouldn't be satisfied by email if he had thought it applied. So we have that argument, but the secondary argument is that it wasn't done at the commencement of the action. It was done after the hearing on summary judgment, before the summary judgment was granted, but after the hearing. I see I'm out of time, so I'll just ask that this court reverse on the attorney's fee awards and affirm on the cross-appeal issues.
Thank you, Mr. Norby. Counselor invited to join us up at the 3rd floor rotunda for coffee. We'll stand at recess.